A Texas man is accused of murdering his wife and then living alongside her decaying body for more than a month. When investigators confronted him, he reportedly responded with 5 chilling words: "Go big or go home." Now, Charles Byrd is behind bars.
Once deputies got into the home, they very quickly smelled the distinct odor of decomposition of a body. They were able to get into a portion of the home where they realized what they were seeing was most likely human remains wrapped up in materials.
I'm Kennedi Walker, and you're watching Law and Crime. Walking out in handcuffs, 49-year-old Charles Byrd was arrested, accused of killing his wife and living with her body for more than a month. As deputies led him away, Byrd reportedly said, "I'm so sorry, I loved my wife," and claimed he had a mental break. His arrest came after a relative contacted police saying Byrd had allegedly admitted he'd hurt his wife, Angela.
A relative of Mr. Byrd actually had not gone into the house. He expressed his concern, and at a certain point, he allowed deputies to get into the house. Once deputies got into the home, they very quickly smelled the distinct odor of decomposition of a body.
Investigators say human remains were covered in carpet, blankets, and trash bags. Authorities believe the body is Angela Byrd's, but they're still waiting on the medical examiner's ruling to confirm the cause and manner of death. After the discovery, Byrd was nowhere to be found, but investigators tracked him to a nearby home where he was allegedly hiding.
He was asked what his end game was. In other words, did he think he was going to get away with this? And he described to us that he felt pretty certain he was going to get caught as a result of it, but he was trying to just prolong the process as much as he could.
Once in custody, Byrd allegedly admitted he and Angela got into a violent confrontation around June 16th and said he believes she died from her injuries.
He mentioned a violent encounter that took part between the two of them, and that he assaulted her, and he was fairly certain that she died as a result of those injuries that were inflicted upon her, and then he took steps to conceal the body.
But what he reportedly said next left investigators stunned.
When he detailed to the investigator that he had not been arrested before, he had never committed a crime before, and then blurted out the comment to our investigator, "Go big or go home."
Byrd was charged with tampering with evidence with the intent to impair a human corpse. Authorities say he will likely be facing at least a murder charge once the medical examiner has completed the autopsy. And here to break down this story with me is trial attorney Bridget Williams. Bridget, thank you so much for coming on today.
Thank you for having me, Kennedy.
So let's just jump right in. When someone allegedly hides a body in their own home for weeks, what does that signal to investigators beyond just guilt?
Well, so when we say beyond guilt, that is a signal we start off with the charge of what he's being charged with, which is tampering with evidence with the intent to pretty much hide a corpse, right? In addition to that, it could also be a potential murder or knowledge of a murder, which is what was signaled here. So when we say guilt, I think that's jumping the gun all the way to if we figure that out in a trial setting or in court, but at least having the probable cause for an arrest. And so he's been arrested already with this charge of tampering with evidence and with the intent to impair availability of a corpse. But he could also be charged with murder, and I could see that coming fairly soon.
Absolutely. And, we know that he, according to reports, he allegedly confessed. That's what the sheriff said as well, that he confessed to these crimes. So when someone allegedly confesses to violence but says, "I had a mental break," how much legal weight does that carry?
Ooh, it carries a lot of legal weight. We start off with so many things about that, of what that confession brings in and how can it be brought into evidence. So we start with when someone goes to talk with police officers and there's no attorney present, was that person Mirandized, right? So the person is in the custody of the police department and they're asking him questions. They have to be Mirandized. So we start there. And then was he, in his right legal mind? Was he in his right mental state? So there's a lot of things that could go on as to, will those confessions be brought into evidence? I don't see anything here that says that they won't be. So I very much so foresee all of those statements being brought into evidence based off of what we know right now.
Does the statement "go big or go home" complicate any potential mental health defense?
I could see it. I could see it complicating that, because it gives certainly an intentional um, statement. To me, it shows some type of intent there. Like, right. So I intentionally did this on a big scale. I've never been arrested before. I've never committed a crime before. So why not go big or go home about it? That is the implication of what he provided to the sheriff's office. So him providing that and saying, well, I didn't know what I was doing, that's going to be really difficult for a defense attorney now to show, well, I didn't know what I was doing. I didn't understand right from wrong. I didn't understand what I was doing when you gave these words of go big or go home. It shows very much so intent.
I mean, could it even, I mean, you took the words out of my mouth, but I'm also wondering, could the defense argue that this was some type of terrible joke? I mean, an emphasis on terrible for someone to say something like this, if he did say it.
I mean, the defense counsel can do as they like, right? I wouldn't recommend it if they were the defense counsel. I wouldn't recommend saying that this was some type of terrible joke, especially moving forward if it was a trial setting. You don't want to present any type of things like that showing that, oh, this was a joke, especially to a jury. This is a serious, serious matter. The life of a woman was taken, his wife. And then for you to say, oh, I was just joking about, go big or go home. That's not a joking matter, and not one that you want to present to a jury.
Absolutely. And we know Mr. Byrd's first charge was tampering with evidence involving a human corpse. How seriously is that treated in Texas?
So tampering with evidence by itself is just a third-degree felony. So let me not just say just, it's a third-degree felony with a punishment range up to 10 years in jail, up to a $10,000 fine. But then once you move forward to impairing, intention to impair the availability of a corpse, then that increases it now to a second-degree felony. So now the punishment range is higher, and it goes up to 20 years in the penitentiary and up to a $10,000 fine.
Let's talk about jury selection. I mean, you've covered a lot of cases. How do juries typically respond to someone allegedly living with the body that they're accused of hiding?
It's going to be interesting for jury selection. When we talk about a voir dire, it's the process of trying to find individuals who can be completely unbiased and someone who can commit to being fair and listening to the facts as they come out in the trial setting. So much coverage has gone on about the stories, and most of the time when they're large stories like this, there's a lot of coverage about it, and it's in the news in different places. So people have already heard about it. So it's sometimes very difficult for defense counsel to have that conversation with members of the voir dire already. But having the conversation about, okay, well, he, one, was living in the house with this body for over 32 days. And then in addition to that, talking about, well, go big or go home, all of that information is going to come out in the trial. So you have to have that conversation with them ahead of time and say, well, can you listen to the facts presented in this trial for what they are and not give any type of preconceived notions about it? However, if I am defense counsel in this case, if we don't have any other information that's being presented to us, the jury trial may not be the best option for him. Sometimes that's a good strategy. It just really depends on the strategy of defense counsel.
If they do a jury trial, I mean, just given the publicity of this case, is there any way that it could get moved to another county?
There's always potential for that because, I mean, any defense counsel or even the prosecution can file for a change of venue, which is just moving it to another county, and the judge agreeing to that or not. They have to have overwhelming evidence in order for a judge to agree to that. So it has to be something where it is completely just such a massive weight of unbiased individuals in the county that will not be able to give a fair trial to this defendant. And a judge then makes a determination on if that is correct or not, and then they'll move it to another county. But that's just it's always a possibility. It doesn't always happen.
Now, getting back just to the nitty gritty of the case, according to authorities, they say that this all started with a domestic dispute. What are common warning signs prosecutors see in cases that escalate to homicide?
That's a good question. So what I would say is that there are, whenever someone calls the police, I know different counties have different rules, but in a lot of counties in Texas, whenever a domestic dispute happens, a lot of police officers will have a rule that someone's going to get arrested, right? Even if it is let's say a Class C assault case, which is like a traffic citation. And so that's just if we had some type of, I offended you when I assaulted you. I touched you. You were offended. And so that happens a lot in domestic abuse or domestic assaults with people that happen at home, families, with husband and wives. It happens often. And so some things that I see is that calls like that happen often. It may have been one or two, sometimes 10 times before where that has happened before. I've had multiple cases where it's increased to not a homicide, but let's say a felony assault case, right? But there were several instances of assault prior to that. Again, even if it's a Class C assault. And so multiple charges of assault prior to that, even at the lowest level, that's one indicator. Two is if other individuals have, will be witnesses to say, well, I've noticed physical altercations between those individuals before. So I would say those two things are the most prevalent, but the thing that I've seen the most is prior charges.
Does the system realistically have tools to step in before something turns fatal, or is it mostly reactive? Because I feel like we talk about a lot of these domestic violence cases, and technically we don't know all of the details yet with this one. But just in other cases that unfortunately result in someone's death, we always say how horrible it is, how, something should have been done, but it always just seems reactive instead of proactive.
Yeah, I think that's a great question. It's every county again is different, but a lot of counties will have different programs set up for victims of domestic abuse cases or family assault cases. So that's a great point that it's reactive. But even if it happens, like I said before, at a Class C level, there are several cities and counties that will offer different programs to the victims in those cases. And it's up to those victims if they want to accept the assistance of those programs. You'll be very much so surprised that a lot of times when they don't want to accept the assistance, that happens often. But they will offer it to victims of assault cases, but it does happen generally at the end or once a person has been charged with this particular offense. It does normally happen after the charge.
If the body is badly decomposed, because that's what authorities say, they said that the smell hit them as soon as they walked in. How hard is it to prove intent, especially first-degree murder?
It's always going to be very much so difficult to prove intent because we never know what someone is thinking, right? So we can only just talk about, well, these are the things that add up to, that show an overwhelming amount of evidence of his intent. So they were involved in an altercation. And then my understanding from reading just different news articles about it was that that it happened at another location and then the body was brought back to the house. So it was brought back to the house, and he lived with that body for quite some time. That doesn't show that he was trying to make it available to the police officer. So that's one. And he doesn't show that he is trying to be cooperative with police officers at all. He waited until there was a warrant to come into the house. So that doesn't show very much so that I am trying to be cooperative with police officers or to let anyone know that my wife has died. So I'm trying to conceal it. So that's the part about the tampering with evidence with the intent to conceal. So that's there. But the intent to murder, I don't think that it shows exactly the intent to murder. We'll have to look at additional information that comes out from the case. But this information from this particular tampering with evidence case, it will certainly come into play for the murder case. It will have some facts that will coincide with each other.
Mr. Byrd reportedly said that he loved his wife. Can that contradiction actually be used in court?
Anything that a person says can be used in court, right? Anything that they say that is done legally can be used in court. So if it is done after a person is being Mirandized, there's not a lawyer present. He's been Mirandized legally, and he decides to give statements of his own, just on his own demise. If he decides that's what he wants to do, everything that he says can be then used in court in an investigation and in future legal proceedings.
And, authorities said he didn't have an attorney. We just talked about that. I mean, just how often do suspects say things that come back to haunt them legally?
It is so overwhelmingly surprising to me how many people agree to go talk to police officers without an attorney present. A lot of times police officers will ask a person who is a suspect in a crime to come in just so we can have a discussion with you. We want to talk with you about the case. We just want to get your side of the story. No, that is not something that a person should ever do without an attorney present, because everything that you tell that police officer, even things that you may think that, okay, well, I did nothing wrong outside of this case, right? Let's just say in general, you think, okay, I didn't do anything wrong. I'm just going to go talk to them. And those things that you may say, you may have violated another crime. You may have done something else. And now you are spilling all the beans, everything, giving them everything. I have seen people go in to talk to officers and be arrested on site after they've given that statement. That happens all the time.
Yeah. And just moving on to the defense, I mean, I'm very interested to see how this is going to play out, how they're going to argue this. But if Mr. Byrd's defense team leans on the mental break explanation, I mean, what would they need to prove? Or what other defenses could they offer?
That's honestly, based on what we know right now, I feel like that's probably the only defense that they probably could lean to at this moment, right? There may be additional evidence that comes out and there may be other defenses. But based off what we know right now, that may be the only defense. And that's why I was thinking that it may not be a trial setting type of case. But let's say that they decide they're going to move forward with that he has a mental break and that's the reason why this occurred. They're going to have a lot of hurdles to overcome because, again, if you murdered your wife and then why did you and you intended to keep the body in the house for 32 days. So that's one hurdle to overcome. Then you make this statement to the officers, go big, go home. That's another hurdle to overcome. There's just several different hurdles of intent that they have to overcome. When we talk about a mental illness, the person doesn't necessarily understand the difference between right and wrong. And that's not showing that I didn't understand the difference between right and wrong. That shows that I intended to do this. I knew exactly what I was doing because I concealed it. And then I admitted to concealing it.
We, again, with going back to, authorities saying that there was maybe allegedly some type of domestic situation. I mean, could a defense lawyer argue that this was an accident despite the aftermath?
I don't think it'll be a good choice to try to say that it was an accident, right? Again, because we go back to you tried to conceal it. Because if it was an accident, why didn't we try to talk with police officers about it or talk with a family member about it? How can we resolve this? And I love my wife, right? That was the other comment. I love my wife. So why am I now trying to conceal it? And why am I saying go big or go home? That doesn't coincide with this was an accident at all. So I don't think that would be a very good strategy for a defense counsel to go with.
Could this be a death penalty case? I mean, this did happen in Texas.
Well, when we talk about a death penalty case, it has to be a capital murder. So when we say capital murder, it has to be a murder case, but then there are several other elements that it has to meet in order for it to be a death penalty case. This doesn't quite meet that standard for it to be a death penalty case. Death penalty cases could be anything of killing multiple people, killing a child, killing an elderly person. There's several different, there's a laundry list of things that it could be, but I don't think this meets that standard.
Is it also like he would have needed to do this while in the process of committing another crime? Because if he did do it, and again, he's innocent until proven guilty, what exactly, what would have reached that threshold?
Yeah, well, when we talk about, again, for death penalty cases, there's several things. There's like a multitude, a list of things that can be a death penalty case. And you brought up a point about, okay, well, if it was in the course of another felony case, but this doesn't sound like the murder happened during the course of the murder case. The tampering with evidence happened after the fact, right? The murder happened on the June 16th, or that's what we think it did at this time. The murder happened on that time period. And then he tampered with evidence by trying to conceal the body after that. So it didn't happen together. So that's why I don't think that it raises to that standard.
Well, this is a story that we will be following closely. Bridget, thank you so much for coming on today.
Thank you so much for having me.
Charles Byrd was booked into the Bexar County Jail, where he is currently being held without bond. For Law and Crime, I'm Kennedi Walker.